Items for delivery of judgment. Item number 53. Cancel over 30,025.
Appeal allowed. Impugn order. Stand set aside in question.
Number 54. CRPIO 313/2026.
Petition dismissed being not maintainable.
Right, please, all. It's a regular bail application, my lord, and in fact, my lord, last order, my lord, he is on interim bail, my lord, 22/6, my lord.
I have done for the order, but he was not called.
Exactly, CD has
Yeah,
to be.
earlier order, my lord. He was not called.
Okay. Heard Mr. Chaudhary, learned counsel for the accused. And also heard Mr. P. Borthakur, learned additional PP for the state respondent. And Mr. Your name, please? U.S. Borda, learned counsel for the respondent number 2. Mr. Borthakur, learned additional PP has pointed it out that though by order dated 22nd of June 2026, interim bail is granted to the accused, yet the CD has not been called for, and as such, he is contended to call for the case diary. Accordingly, it is provided that Mr. Borthakur shall produce the case diary before the court on 6/8. Till then, interim order passed earlier shall continue.
Much obliged.
Item 2.
May I please, your lordship?
Yes.
This person was arrested on 18/6/2026, lordship, in connection with Huang Police Station case number 15/26. Sections are 147, 148, 308 clause 2, 61 clause 2 of BNS, and read with section 10 and 13 of Unlawful Activities Prevention Act, lordship. May I read the FIR, lordship? It is in page number 13, lordship. As per FIR, an information was received on 7/6/2026 at Huang Police Station that one Lambit Gogoi, son of late Toriko Gogoi, resident of Baktholi Pothar, PS Huang, had been missing. And accordingly, an inquiry was initiated. During the course of inquiry, all details, records of the missing person bearing mobile number 600-200-9901 were obtained and analyzed. In the meantime, another person, namely Probin Sonwal of Khoang, reported at police station that he had received extortion calls.
So, madam, for how many days the accused is behind the bar?
From 18/6/2026.
18/6. Mr. Borthakur, what is the mandatory period?
Here by lot 90 days, and there is also provision to extend that period.
90 days in under which section?
But UAP under section number 23D, मतलब 2, and under section
No, here the sections are only 10 and 13.
Yes.
10 and 13 years. 10 and 13 years. The mandatory period is 90 days.
Is it?
10 and 13 years. Yes, my lord. Grace shall not be less than, my lord, 5 years, may extend to imprisonment for life.
13.
Yeah,
Okay, let the CD come.
yes, sir.
CD on when?
Eleven.
11th of August.
Obliged, lordship.
Item 3.
May I please the Lordship? Lordship, this case is registered under section 22C, Lordship. Case diary may be called for, Lordship. It is
From
110
which PS?
It's from Shri Bhumi, Lordship.
Pardon?
Shri Bhumi.
Srivumi.
Yes, Lordship.
Okay. CD on Bortagor?
19.8 mil.
19.8. Okay.
Highly obliged.
May I please the Lordship? Lordship, here, my lord, allegation is, my lord, stolen of a cow, my lord. But, my lord, that though we have filed this, my lord, bail application, but, my lord, here, one legal issue has arisen, my lord, that, my lord, that whether a committal court can, my lord, take cognizance, my lord, of a session tribal sections, my lord. And, my lord, second one is that, my lord, whether a magistrate court can, my lord, entertain bail application or
if
not.
you
my
are
lord.
challenging the cognizance order taking cognizance by the committal court,
Yes, my lord.
you have to file a revision petition. This is in bail application.
My lord.
Can we
here-
consider that aspect in bail application?
My lord, yes, my lord, we have filed this bail application, but here in this case, my lord, this issue is, my lord, we are facing, my lord. That is why we have mentioned categorically in the bail application as well, my lord. So lordship will decide.
No, in a bail application, can we consider that aspect? Where the case is pending now?
My lord, SDM, Sodor, my lord, Lokhimpur. Page number 2 of my bail application, my lord.
When he was arrested?
On, my lord, 24/5/2026. As on that 66 days, my lord.
66 days.
Right, my lord.
What is the mandatory period
Mandatory is 60 days, my lord.
for the offenses?
But, my lord, this is session tribal Act because, my lord, they have inserted, my lord, sections under Assam Cattle Preservation Act 2021. That is the only problem, my lord. Otherwise, it is
Cattle
a case of
Preservation Act
cow.
2021. Which section?
My lord, Assam Cattle Preservation 13(1), my lord.
What is the maximum period prescribed for the
7.
seven or 8?
Assam Cattle Preservation.
Let the city come.
My lord, not CD, it will be, my lord, TCR. TCR.
Oh, it
because
is already surseated.
Surseated case and it is pending before, my lord, SDJM Sodor.
Okay. Resist will call for the TCR from the Court of Learned, SDJM,
SDJM Sodor, my lord, Lokhimpur.
Lord not looking for. Fixing the matter on.
Before
14th August.
14.
No. Sorry.
7th August.
7th of August.
Oblige, my lord.
Item 55.
My please, my lord. No, this is anticipatory bail application, my lord. FIR is at page 11, my lord. Allegation is of theft of cow, my lord. Page 11, my lord.
What are the sections?
My lord, sections are, my lord, 305A, 3172, 317 for 336(2) of BNS. And, my lord, section 11 of prevention of
Cattle
cruelty.
Preservation Act is there.
Yes, my lord. My lord,
So, when he was arrested,
my lord, this is anticipatory bail application.
anticipatory. Okay.
My
Then
lord,
let the CDB come.
my lord, the case is that, my lord, the petitioner is the owner of the vehicle, my lord. And, my lord, the vehicle was set on fire by the local public, my lord. The vehicle was detained. And at that time, the petitioner was not present, my lord. Vehicle was set on fire. His driver was assaulted. And, my lord, then when the police come, my lord, he has seized the cow. And, my lord, as per the allegation in the FIR, my lord, the driver says that the owner has handed over the cows, my lord. I have the sale certificate, my lord. That is at page number 17, my lord,
Sale certificate of.
of the cows, my lord, the cattle. He has purchased
No, that's
the
already, you were the owner of the
vehicle,
vehicle.
my lord.
FIR, it's that he's not only the owner, but it also revealed that the present owner of the state vehicle is was Ricky, the present petitioner for half Sananda of years. And the released driver, the present received the same cattle from 3 unknown persons in presence of the
Honor, my lord.
same Ricky.
Okay, so that you call for the case again.
My lord, page 17, my lord, the certificate issued by the Gauhati, my lord. Cattle sale certificate.
Maybe we'll see the case diary.
Till then, he may be protected, my lord. He is the owner, my lord, and vehicle
Maybe,
is
maybe.
set, placed by the public, my lord. This is nothing that, my lord, this is stolen, my lord. Page 17, my lord. This is issued by the Gauhati, my lord. Type copy in the originally that page 18, my lord.
Whether the Gauhati can issue sale certificate.
My lord, these are the cows in
You purchase it from where?
my lord,
From the market?
no, this is not a market, my lord. Different persons, my lord, because there is no such, my lord.
Or whether Gauhati is authorized to issue sale certificate?
No, he is not authorized, but my lord,
Then?
to show that my lord, he has, my lord, the Gauhati knows, my lord, all these things, my lord. That's why he has issued. And my lord, his wife in the,
Proceeding.
my lord, his wife is in the advanced stage of pregnancy, my lord, and he said.
We'll say we'll fix short date.
5th of August.
5th of August. CD on 5th of August. No interest.
Obliged.
Promotion, item 5.
Made for your lordship. Lordship, I have filed this petition, lordship, challenging the freezing order, lordship. Challenging the freezing order, lordship. What has happened, lordship? I am the lordship. In this case, I am the company, lordship, and there was a raid, lordship. Was a search and seizure operation happened in one of the directors' home, lordship. One in Gauhati and the other is in Silchar, lordship. Then, lordship, during a search and seizure operation by the ED, lordship will find at page number 32, lordship. He has prepared a panchnama. Lordship may kindly peruse the panchnama once first. Lordship, in page number 31. Annexure E. May I just read, lordship?
Not necessary. You want to file your reply?
Yes, my lord.
Affidavit. When?
Yes, my lord. Otherwise, my lord, this petition is not maintainable, my lord.
How?
My lord, why? The Supreme Court has laid down the law, my lord, how it will go. High Court is not forum, my lord. At this moment, my lord, once under 17, a seizure is done, my lord. Within a short period, we have to, my lord, under section 8, we have to send it to the AAO, executing authority, my lord, executing authority in Delhi. There is a 3-judge bench, my lord, by an ex PLMA. So they will, within 30 days, my lord, again we have to file an OA, original application for whatever it is. They will get a notice there from there. Then they have to go and contest it. That is what Supreme Court has laid down the law, my lord. I can go through it, my lord. Then thereafter there is an appellate tribunal. Then, my lord, under in a division bench, she has to come before the High Court. That is the laid down law by the Supreme Court. So this is very premature, my lord, for a writ. That is the laid down law. How it will be.
May I?
I can just, my lord, show them go, my lord, how it is. What Supreme Court has laid down, my lord. That is the code now.
First, I'll let him argue.
My lord.
Yes.
My lord, I have gone through this, lordship. That nowhere it states that I cannot file a premature case, lordship. This is not a premature case. I have filed it. Lordship may kindly see my panchnama. I will. The reason why I have filed it, lordship will find why I have filed this. And lordship.
No. Your grievance is only against the freezing order.
Yes, lordship.
Yeah.
That freezing order, lordship, may I will just place the law how a freezing can be done and under what conditions I can file a writ petition. Lordship, in the P. Chidambaram case, everything has been made clear as to how the ED has to work with regard to freezing, lordship. Now, the panchnama has, lordship, may kindly peruse the panchnama once, lordship. Page number 31. We, the above mentioned punches, have been called by Sri Basab Bhattacharya, Assistant Director, Directorate of Enforcement, Agartala Subzonal Office, have presented ourselves at the residence of Sri Abu Ahmed Mazumdar. That is one of the director of the company, lordship. Here, we were shown an authorization number, so-and-so, issued by Banibrata Datta,
Deputy Director, Directorate of Enforcement, Gauhati Zonal Office under subsection 1 and subsection 1A of the Section 17 of the Prevention of Money Laundering Act 2002, authorizing Sri Basab Bhattacharya, Assistant Director, to conduct search and seizure of the freeze of the premises, house number so-and-so. At around 6:25 a.m., we reached the premises along with the officers of the Directorate of Enforcement CRPF personnel. After opening the door of the premises, we found Sri Abdullah Ahmed Mazar Bhuya, nephew of Abu Ahmed Mazumdar and sister of Abu Ahmed Mazumdar. At the said premises, Basab Bhattacharya, Assistant Director, introduced us to Sri Abdullah Ahmed Mazar Bhuya and family members and showed the authorization of search bearing number so-and-so, dated so-and-so. And we explained the contents of the said search warrant to Sri Abdullah Ahmed Mazar Bhuya and put his as well as our dated signature on the search warrant as token of having seen and read the same. Before the actual start of the search, the Basab Bhattacharya, Assistant Director, introduced his accompanying officers, so-and-so, and subsequently offered their personal search, which was politely declined by Abdullah and the family members in our presence. On being asked, it is informed that the premises consisted of G3 houses. Each floor consists of 4 rooms, and we have kitchen in hall. The search operation started at 6:25 hours on 3/7/2026 and concluded at 8:40 p.m. 8:40 p.m. on 3/7/2026. During the search operation, the premises have been thoroughly searched and various documents and electronic devices have been thoroughly checked. As a result of the search, 4 electronic devices has been seized, the details of which has been mentioned in the appended schedule. During search operation, statement of Abdullah so-and-so was recorded under so-and-so. The search operation concluded in a peaceful and orderly manner, and damage to the property has been done during the course of search. Religious sentiment of everyone were duly respected during the search. At the conclusion of the search proceeding, the officers of the Directorate of Enforcement offered their personal search, which was politely declined by the Abdullah Ahmed Mazar Bora and the family members in our presence. So this is it. They have searched the house for more than 14 hours. And they have seized some electronic documents. That is what it says, nothing more. Now, Lordship may come to the freezing order. In page number 39, the impugn order, Lordship. Whereas I, Basab Bhattacharya, Assistant Director, Enforcement of Directorate, authorized by Bani Broto Dotto, so-and-so, to conclude search, seizure or freezing under Section 17 of PMLA 2002 at the residential premises of Abu Ahmed Mazumdar for the purpose of investigation under PMLA. Hereby make an order to freeze the below mentioned account, as it is not practicable to seize the balance lying in the below mentioned accounts. Now, these are the details of the account. Now, all these Lordship, in serial number 4, the account of the company has been seized. That is not the account of Abu Ahmed Mazumdar. That is the company's account. Now, Lordship may further come, Lordship. I have further ordered
Is there
that
any bar in freezing the account of the company?
no, that is not my, that the company, the account is the account of the company, not that person's. What they have done, basically, they have seized everything. There is a blanket seizure. Now, Lordship, the law is very clear with regard to how a seizure has to be done. Lordship, may kindly take up
No.
Section 17 of the.
Seizure and freezing, whether the same thing?
No, it is different, Lordship.
Then?
Seizure is done under Section 17 and freezing is done under Section 17, subclause 1A. What happens, Lordship, when something is inside an account that cannot be seized? That's why they freeze it. Now, my learned friend is correct that he has to, within 30 days, he has to approach the adjudicating authority saying that I have freezed this account. And if there is any more intention required, then application has to be made by them to the adjudicating authority. If he passes an order saying that yes, this, it should be further detained, then it has to be further detained. And if it is said that no, it is not required to be retained, then it will be released. Now that is settled. I am not on that, Lordship. But what happens, Lordship, when a person, the most important thing to be done is the officer who has freezed it has to give his reasons in writing. That is the mandate of law. Now, Lordship may kindly, I'll just
No,
place a
whether
judgment in.
any region is assigned in this impugn order?
No, Lordship, that is what my case is, Lordship. That is,
My lord, I will tell you.
no, I know what you will say.
Friend is just wasting the time of this honorable court. Very precious, my lord. Reason to believe where writing and where whom to give. My lord,
Lordship, let me submit, then Lordship will decide if I'm wasting the time of the court.
Hmm. Okay,
Lordship will decide that,
Okay.
not him. Lordship, what I'm telling, what he is trying to say is under section 17, the deputy director has to form an opinion.
Hmm.
On the basis of that opinion, he has showed me his opinion. He has come to my house. My deputy director has said, this is the opinion of him. That's why I will search the house and I will seize the property. That is not the law. The Supreme Court is very clear. The person who is seizing it has to record the writing. PMLA Act is a stringent act.
Hmm.
So what happens if a
Hmm.
deputy director is
So,
sitting inside
you
somewhere
are-
else, he
you
will
are-
say that I have reason to believe that there is some money laundering happening in someone's house,
Okay.
and send the person there,
Okay,
and the
Mr.
person goes.
Dekar, you are relying upon a decision of the Supreme Court. What is that decision?
Lordship, it is actually this is decided. There's several decisions, but I am just relying on a judgment of the Delhi High Court, JK Tires and Industries versus Enforcement Directorate. In that case, everything which has been considered by the Supreme Court has been considered. It's a compendium of the.
What is the decision of the Supreme Court? What is
The
the citation
decision
of the Supreme Court?
Court is that, Lordship, while a person.
No, you give me the citation of
Lord,
the Supreme Court
please,
decision.
Lordship, may kindly. Lordship, it is not that a deputy director has authorized the assistant director. That's why the assistant director will not record anything. He will simply come and seize everything. That is not that is not how ED works, Lordship. Since the provisions are stringent, the action has to be stringent also. Lordship, may kindly take para number 58.
Yes.
In P. Chittambaram versus Directorate of Enforcement 2019 9 SCC 24, the Supreme Court analyzed the scheme of Section 17 of the PMLA and held.
Hmm.
Section 17 of the PMLA deals with the search and seizure. Section 17, which deals with search and seizure, states that where the director, that is what I was submitting, Lordship, or any other officer below the rank of deputy director authorized by him for the purpose of this section on the basis of the information in his possession has reason to believe, reason for such belief to be recorded in writing, that any person has committed an offense which constitute money laundering or is in possession of any proceeds of crime involved in money laundering. That is important. There has to be proceeds of crime. May search building, place and seize any record or property found as a result of such search. Section 17 of PMLA also uses the expression reason to believe and reason for such belief to be recorded in writing. Here again, the authorized officer shall immediately on search and seizure upon issuance of the freezing order forward a copy of the reason so recorded along with the materials in his possession to the adjudicating authority in a sealed envelope in the manner as prescribed, and as such the adjudicating authority shall keep such reasons and materials for such period as may be prescribed. In order to ensure the sanctity of the search and seizure and to ensure the safeguard in exercise of power under Section 73 of the PMLA, the central government has framed the Prevention of Money Laundering Form, Search and Seizure and seizing and a manner of forwarding the reasons and materials to the adjudicating authority, impounding and custody of records and the period of retention rules 2005. The division bench of this court in Directorate versus Abdullah Ali Balsharaf and others, the same decision
Mr.
was
Deka,
Lordship.
okay. We'll go through the decision of the Supreme Court in the case of P. Chidambaram. And what is your decision?
My lord, Vijay Madan Lal, my lord. I have a copy, my lord.
Okay. Let us fix a very short date.
Lordship.
We'll hear on the point of maintainability
Lordship.
on Thursday.
Lordship.
Thursday.
Thursday, Lordship.
This Thursday, my lord.
This Thursday.
My lord.
Okay. Heard Mr. Dekar, learned counsel for the petitioner. And
My lord, let me just put the which I will be, my lord,
relying upon.
relying, my lord.
Okay.
My lord.
And also heard Mr. Dor, learned counsel for the for all the respondents.
Right.
All the respondents. List the matter on Thursday. Can we fix at 2 p.m.?
My lord,
2 p.m. At 2 p.m. For hearing on the point of maintainability of this petition. Yes.
my lord, there are 187, 193, 195, 198, 200. And 382.26 and 27. These are relevant paras, my lord.
Mm.
How our result to believe is to be written and where it is to be sent. And then how the proceeds, my lord, how the case will proceed. It is laid down by the full bench of the Honorable Supreme Court, my lord. This is not from a division bench of any high court, my lord. This is the code. This is the law, my lord, as of today, which is standing for India, my lord. This entire PLMA was, my lord, provisions are challenged, and Supreme Court in a full court, my lord, has come up with this judgment. So, my lord, this is, as of today, this is the law.
Okay. We'll go through the same. You also go through the same.
Lordship.
You know about this case
Lordship, I know.
on Thursday at 2 p.m.
Highly obliged.
My lord, keep a further hearing then. As part heard, my lord.
No, for motion, Lordship, because notices are not issued till now. Because I need the notice, Lordship.
I think my lord is taking up for disposal.
No, Lordship,
No, on that day we will decide the matter
My lord,
whether we will entertain this petition or not.
my lord, my lord.
highly obliged.
6.
Here, my lord, I have essayed an order passed by the learned additional judicial magistrate Kamrup, whereby Zimma of my cattle has been rejected, my lord.
Hmm.
Order is at page number 98. Although there is no dispute in the order regarding the ownership, but because of cruelty, my lord, allegations of cruelty, my Zimma was rejected, my lord. From 98, Exar 9, my lord, impugn order is started, my lord. And operative portion is from 100 and 101, my lord. Although my Zimma petition was rejected, but I was directed to pay the expenditure of the kettles. My dilemma is that, my lord, out of the 111 kettles, my lord, already 15 kettles has already been died in the Goshala, and that is reflected in another order, my lord. I filed in Zimma petitions for other articles, my lord, wherein it was placed before this honorable court by the learned colleague, my lord, that out of the 111, 15 cattle has already been died, my lord.
No, now you tell me how this order is illegal or arbitrary?
Because, my lord, I have produced all the documents, my lord, regarding the ownership of the cattle and the FIR basing on which my cattle was seized, my lord. That FIR is regarding the another crime committed in another place, my lord. Later on in that FIR, I was arrested along with cattle, my lord. Several other articles has been seized from my house. So thereafter, I filed in Zimma petitions. I submitted all documents, my lord. So, or even the ownership. And so far the cruelty is concerned, my lord, that cruelty is reflected regarding the another batch of cattle which was seized from the place of occurrence, which is at Rani, my lord. So these two, regarding the cruelty, my lord, these two incident does not, my lord, coming from the same incident, my lord. And that apart, all my cattle are seized from my shed, my lord, not from any other place during the transportations or any other. And this is reflected in the FIR itself, my lord. So at this stage, my lord may call for the record, my lord. Only a short
Where,
date, my
where
lord.
the case is pending now?
Case is now pending before the, my lord,
Amingao.
Amingaon, additional CGM, my lord.
Okay. Mr. Borthakur, let the record come then.
Yes, well, otherwise, my lord, I may be wrong, but it would be appropriate to make, my lord, to make Dhyan Foundation is also a party, because those, my lord, cattle were handed over to Dhyan Foundation.
Here, my lord, no,
Some of the
no, that is,
regarding well-being of those cattle and everything.
No, Mr. Borthakur, this is not a writ petition. This is a revision petition against the impugn order.
regarding the death of the cattle's, my lord, it is reflected.
We are
in
not
presentation.
deciding any right, title, interest of any of the parties.
Yes,
We are only testing the correctness of the order.
yes.
Heard, Mr.
MAI, he said.
Learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. Legality, propriety, and correctness of the order dated 6/6/2026 passed by the learned additional Chief Judicial Magistrate Kamrup Amingaon in petition number 1172/2026 filed in PRC case number 502 of 2026 is challenge in this revision petition under section 438 read with section 442 of the BNSS 2023. It is to be noted here that by the impugned order dated so and so, the learned additional Chief Judicial Magistrate has dismissed the Zimma petition filed by the petitioner seeking custody of 111 numbers of cattle seized by police from his residence. After hearing learned counsel for both the parties, it is provided that Resi shall call for the scanned copy of the record from the Court of Learned Additional Chief Judicial Magistrate Kamrup Amingaon, fixing the matter on
Number 7.
Lordship, can the matter be done for the time being? My senior Mr. HR is already.
okay.
Item 8.
In this case, my lord, the petitioner has filed this criminal petition challenging the FI which was lodged against the petitioner. At page 21, the handwritten one is at page 25, 21, my lord. I, Sri so-and-so, would like to lodge a formal complaint against my boss so-and-so. I've been working in this shop for the past 11 days. Today, while I was work, my boss so-and-so told me to take so-and-so on or an item as a bihu gift from his side from the shop. After that I took and going to the changing room and wear it. Then when I came to the shop, he's asking me to open the shop top and show him the fitting of the so-and-so. Therefore, I request you to kindly take the legal action against the accused and ensure justice is served. So this was on 15th of April 2026, my lord. And the petitioner, he has a shop in Ganeshguri market, my lord. Bhigu market, my lord. So it was on a Bihu day. So and it was full of crowd, my lord. It was a daytime, my lord, and moreover, my lord, what has happened, my lord, is that the respondent number 2, she has stolen some articles. So as a counterblast, this FI has been filed, my lord. And
whether any FIR was lost by the accused?
no, we had not lost because it was just on Bihu day. And what moreover, my lord, it was a practice of on our part, my lord, on the part of petitioner, that before the new stocks come in, we hand over the earlier stocks and it to all the employees, not particular to her. And there was no changing room, my lord.
Okay, let the CD come.
Yes, my lord.
Heard Mr. Count, learned counsel for the petitioner. Mr. P. Borthakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has prayed for quashing the first information report dated 15/4/2026, upon which this poor PS case number 214 of 2026 has been registered under section 75 within bracket 1 within bracket Roman 2 stroke 75 within bracket 1 within bracket Roman 4 stroke 79 of the BNSS 2023, and also right for quashing all consequential proceeding arising therefrom. After hearing learned counsel for both the parties, it is provided that Mr. Borthakur shall produce the case diary of Dispur PS case number 214 of 2026 on
20
sorted third week of August,
Yes.
17 August,
17.
17.
Steps upon respondent 2, my lord. Respondent 2 is there. I have to take steps, my lord.
Who is the respondent number 2?
The informant, my lord.
Informant. Also issue notice to the respondent number 2 returnable on that to today. Step be taken by faithfuls and also by usual process within a week from today. However, no formal notice is required to be issued to respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day.
Made Your Lordship. Madam, the petitioner is a assistant engineer of Pollution Control Board. The allegation in the FIR was in relation to the discharge of his official functions. The FIR is at page 44, the Azhar, page 44. I am the owner of the hotel known as Hotel Angel. It is situated Mission Side, Tezpur. I required a NOC from the Regional Pollution Control Board, Tezpur, for my hotel business, for which I was required to install an ETP, effluent transfer plan, as per government norms. I approached the office sometime in September 2019. In the office of the Regional Police Control Board, Tezpur, I came across the then Assistant Engineer of Regional Pollution Control Board, Tezpur, Sri Midul Borua, who showed me of issuing the NOC and asked me to deposit rupees 60,200 initially as consent fees of pollution control board along with necessary documents. I deposit the amount through a demand draft. So therefore, upon his suggestion, I made further deposit of rupees 40,100 on 66/20 and rupees 25,100 on 12/4/21 for demand drafts. Thereafter, he asked me to pay him in additional on case of 2,40,000 for installing an ETP, this effluent treatment plan, in Masjid Hotel. I paid him money. It is more than 2.5 more years since then. Sri Middle Pro has not done anything to get me the NOC. As promised, he made promises in order to extract money, especially that one that he took in cash. I need to comply with the pollution norms in order to have the requested permission from the board. I'm unable to have the same due to the false promises made by Sri Middle Borua. He has been transferred from Tezpur and is now posted at Gauhati office. He used his official position for the Tezpur office in order to influence me and to convince me that he would able to get the necessary NOC if I paid the money. Even after paying the money, I have not been provided with necessary NOC. What has happened? He has applied on the COVID time. The portal was closed. Therefore, the police has filed a charge sheet without taking without any prior sanction from the competent authority. And the learned court below has taken condition under section 406 and 408 of the IPC. The two sections cannot coexist, and without any valid section, no, the learned magistrate cannot take condition of those sections.
No, you were challenging the FIR here.
FIR, entire proceeding.
Entire
Entire
proceeding.
proceeding. And the Supreme Court in this case has been clear in recent judgment in Sunita Totijia case,
Mm.
paragraph number 32.
Mm.
And about the two sections cannot be come together because they are completely apart and they are going to be coexist together. This is another judgment of the Supreme Court.
No, Mr. Gogoi, in this quashing petition, can we consider those aspects?
Yes, because prior sanction is necessary as what is judgment, Your Honor.
Mm.
Prior sanction under 197 is necessary. For if he discharged in an official function, what
Mm.
capacity was doing in his
Then
official
why don't
function?
you file one discharge petition before the learned trial court?
Your Lordship, if the sanction is if the sanction is required,
Mm.
the court can take the order is abuse of person of court is illegal because
Mm.
sanction is required as per the phrase of the Supreme Court. Because without any valid section 197,
Mm.
may I read?
No, that is there. But whether in this case a sanction will be required or not?
Your Lordship, no sanction is because these are some official function.
Mm.
He was doing his job.
Mm.
Your Lordship, after 2 years, he have lost, 2.5 years, he lost the FIR.
Mm.
In a long-term period, he has applied, but in the meantime, he was transferred. After his transfer, after more than 1 year, he has lost the FIR. The gap is around 2.5 years.
Mm.
After transfer, he has lost his FIR. After his transfer in 2021, it was lost in 2022. Initial application was given on 13th 2020 at the time of COVID. But it was not functioning. In the meantime, the portal, it is online portal. The portal has become closed.
Okay, let notice go.
Your Honor may see just one paragraph. Please.
Mm.
Hurry to. Paragraph 32. Therefore, we are of the opinion, last page, that learned magistrate was not right in taking cognizance of the offense against the appellant without there being any sanction for prosecution granted by the competent authority. Further, the High Court erred in not considering the fact that a sanction for prosecution was not granted by the competent authority under section 197 of the CRPC. And eventually, the sanction was expressly denied by the competent authority with respect to the allegations against the appellant. The necessary action not having granted has preceded the very initiation of the criminal proceedings against the appellant herein. Consequently, the charge sheet, the summoning order,
We
and
will
the
examine the matter. Let
if any
notice go.
taken by the trial court person was same, our liable is passed. And second one you receive is this Arshad Nayas Khan case, para 21.
Mm.
The two sections can coexist together. Para 21. Further, it is particular to mention here that if the case of the complaint in response number 2, that the offense of criminal breach of trust as defined under section 405 IBC, punishable under section 406 is committed by the accused, then in the same breath, it can be said that the accused has committed all the offense of cheating as defined in section 4115, punishable under section 420 IBC. This court in Delhi Race Club
No,
Limited versus
Mr. Gogoi, the trial court has taken cognizance.
yes under section
Height
4,
order dated 17/9/2022.
yes,
And this order is not specifically challenged here, though the proceeding is challenged.
yes, it is perfectly challenged.
Mm.
Entire order is challenged.
Okay, let notice go. Heard Mr. Gogoi, learned counsel for the petition. And Mr. Portakur, learned additional copy for the state responder.
Yeah.
In this petition.
Your order is challenged. Impugn order is in page 3. The entire order is challenged from conditional taking because earlier the someone was served. Court can set aside the
Therefore,
opinion order
quoting
79
the
details setting.
FIR of
Page 25.
25/4/2022
It is silence.
registered.
Page
Upon
25.
which Tastur PS case number 630 of 2022 under section 406 for 20 IPC has been registered. And the impugned search sheet date search sheet number 660 of 2022 dated 31st of July 2022 and the order dated 17/9/2022 passed by the learned magistrate judicial magistrate first class Sonitpur in PRC PR case number 1365 of 2022 arising out of zero case number 1139 of 2022 and number D, all subsequent orders passed pursuant thereto. And number E, the entire criminal proceeding of year case number 1365 of 2022 arising out of zero case number 1130 of 2022 pending before the court of learned judicial magistrate first class Sonitpur. Peruse the petition and the documents plus on record. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process upon respondent number 2. In 1 week. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, the requisite copy of the petition will furnished to him during the course of the day. Registration call for the scanned copy of the record along with the case diary of Tasspur PS case number so and so from the Court of Learned Judicial Magistrate First Class, Tasspur, Sonitpur. Please the matter.
In the meantime, yes, they may come because the issue of the process is abuse of power because no sanction was given. Because discharge duty of discharge
We'll
duty.
go through the record. Next date we'll consider interim period of the petitioner will be considered on next date.
Date may be fixed. Date may be fixed. 2nd September. Must applies. 11.
May I please, your lordship. My lord, this petition is for quashing of an FIR, my lord. And FIR page 29, my lord. And what happened in this case, my lord, one after another, my lord, FIRs regarding the same subject matter are being filed, my lord, against this petitioner, my lord. And my lord, I impugn FIR page 29. It is alleged that, my lord, 1,28,206 rupees I have transferred from my account, my lord, because I was, my lord, head accountant of a particular company, my lord. And my lord, before that, my lord, kindly see, my lord, page 41, my appointment letter, my lord, page 41. My lord, page 41, my lord, under one, I was a head accountant of a, my lord, company, that is, my lord, Sangpur Group, my lord. And under that companies, my lord, several entities are there, my lord. Sangpur Honda, Sangpur Teas Private Limited, Ramdhenu, my lord. 7 and there, my lord, last para, my lord. Further, some new entities will be add under Sangpur Group in future. It is your duty to look after accounts of the same. My lord, incentive remuneration will be provided from the said newly add entities, my lord. So I was the head accountant of all these companies, my lord, entities, my lord, under Sangpur Group, my lord. But, my lord, now, my lord, one after another affair, my lord, by this, my lord, all these entities under Sangpur Group, my lord, are filing, my lord. So my humble submission, my lord, there should be one affair, my lord. Kindly, my lord, turn to page 44, my lord, earlier affair, my lord, page 44. I have annexed all the affair, my lord. In that affair, my lord, kindly, page 44.
Page
44. And relevant para, my lord, page 47. Page 47. Here, my lord, this affair was filed
this
by.
affair is lost by wrongdoing tea.
Yes, my lord. Wrongdoing tea state, it also, my lord, under, my lord, Sangpur group, my lord. Entity, my lord. So several 18 entities are there, my lord, under Sangpur group, my lord. So I was looking after all these, my lord, entities, my lord, under Sangpur group, my lord. So now, my lord, kindly, my lord, turn to page. In this case, my lord, I granted interim bail, my lord. Kindly turn to page, my lord, 51, my lord. What happened, my lord? Kindly see, my lord. 51.
Huh.
51, my lord. In this case, my lord, I was granted interim bail, my lord, and I was directed to appear before the landed, before the, my lord, investigating authority, my lord, within 7 days, my lord. My lord, within 7 days. But, my lord, I could not appear because, my lord, some threats are there, my lord. Several other affair will be lodged against me, my lord. That is why I again, my lord,
petition, you're granting bail or
my lord.
refusing bail does not matter in this
But
matter.
kindly, but what happened? Kindly see, my lord, because my lord, then, my lord, kindly please page 54, my lord. Page 54. Kindly see, my lord. Because, my lord, when
54 is the bail order.
yes, because, my lord, when, my lord, interim was granted, my lord, we did not appear, could not appear because there was threatened, my lord. Again, my lord, we approached before this honorable court that, my lord, another affair may be lost. Intercepted bail was filed, my lord. In that case, my lord, a report was called for that whether any other case apart from this case is pending or not. My lord, report was called for and report was received from the several police stations that no other cases are pending, my lord. When, my lord, we appeared before the, my lord, investigating authority, my lord, after our appearance, another affair was lost, my lord. Kindly turn to page. That is, my lord, 61, my lord. Because, my lord, till 9:40, my lord, PM. At 9:40 PM, we appeared. Till then, my lord, no case was there, my lord. After our appearance, another affair was lost and registered, my lord. Kindly page 61, my lord. 61. And 65, 11%, 65. Same account numbers. This is, my lord, Sangpur Honda by. Same accounts number, my lord. Now, my lord, when, my lord, in both these cases, we were granted bail, my lord. Again, my lord, the present impugn affair has been lost, my lord. And both these cases, my lord, are under investigation now, my lord, because, my lord, if investigation is pending. So, my lord, if subsequent any, my lord, developments, my lord, they have come to know, my lord, then, my lord, should come under the investigation of these cases, my lord. But separate affair cannot be registered because, my lord, there are, my lord, several entities.
Let
under
notice
Thankful
go at
Group.
this is this. Heard, Mr.
Yes, yes, Shikdam.
Learned counsel for the petitioner and Mr. Bortakur, learned additional PP, provides the respondent in this petition under section 528 of the BNSS 2023. The petitioner has right for causing the FIR dated 17/6/2026, which was registered as Gulagat PS case number 130 of 2026 under section 314 stroke 316 within bracket 4 stroke 318 within bracket 3 stroke 336 within bracket 3 of BNS 2023 and all criminal proceeding based thereon. There is the petition and the documents placed on record. and also especially the FIR of Golaghat PS case number 130 of 2026. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to respondent number 1 since Ms. Apothagor entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the call for the case diary of Golaghat PS case number 130 of 2026. No, yeah, here search sheet is not submitted. You have to produce. The learned additional PP shall produce the case diary of Golaghat PS case number 130 of 2026 before this court on till returnable date, further proceeding of Golaghat PS case number, further investigation of Golaghat PS case number 130 of 2026 stands state. Since the learned counsel for the petitioner has apprised this court that multiple FIR have been lodged against the present petitioner by Sangpol
My lord, by Sangpol T company,
Private Limited.
company Sangpol Honda under Sangpol Group.
First FIR is lodged by one Sangpol Tea Private Company Limited, and second FIR is by not by the Wrongdoing Tea Company, and third FIR, my lord, that is, and first the present FIR is the my lord. That is
Sangpol Tea Private.
subsequent FIR,
Sangpol Tea.
First FIR dated 11/4/2025, wherein my lord, there is allegation of more than 3 crores, my lord, against the present petitioner. That was filed by the my lord.
Okay, even then you cannot file a multiple FIR
And
against the same person.
all are under
That TT Anthony case,
Yes.
list the matter after 2nd September.
Man, can you interim, my lord? Further proceeding statement.
Dictated.
My lord, Hilum.
May I please, your lordship?
Mm.
My lord, the petitioner was arrested on the strength of the NBWA, my lord, that was issued on, my lord, 31/3/2026, my lord. My lord, he was arrested on 21/4/2026, my lord. And as on date, my lord, the petitioner is behind bar, my lord, 90 days in custody. My lord, here during the trial, my lord, during the investigation, my lord, the petitioner was on court bail. Thereafter, charge sheet has been filed, and after charge sheet has been submitted, my lord, the learned Chief Judicial Magistrate Tezpur, my lord, had take cognizance, my lord. My lord, will come, please come to page number 29, the cognizance order. The order dated 31/10/2025, my lord.
No,
There-
are you behind the bar now?
My lord, NBWA was issued. What happened, my lord? The case is a
No,
session trial,
you are still behind the bar.
my lord. So, my lord, here what happened, my lord?
No,
I was
the
on.
petition is can we section 528 of the bill of which I got?
This honorable. Because I was arrested on the strength of an NBWA, my lord. Here what happened, only one day, the petitioner was absent. The case was session tribal, my lord. The learned Chief Judicial Magistrate directed me to appear before the session court with a date fixed, my lord. On the said date, my lord, I was absent, my lord.
Mr. Hello, you say there is a decision of Supreme Court unless extraordinary circumstances demonstrated.
My lord.
Under this quashing petition, court cannot grant bail.
My lord, here in my case, my lord,
Mm.
Lordship kindly, I have annexed a copy of the bail order, rejection bail order passed by the learned session judge, my lord. In page number 45, my lord. First paragraph. There are all total 3 accused persons, my lord. Seen the bail application filed on behalf of the Atul Mida, the present petitioner, heard both sides, perused the case record, and it is seen that the learned committal court has specifically directed the said accused to appear before this honorable court on 31st 2026. However, the said accused did not appear on the said date before this court, and so NBWA was issued against him. And on 21/4/2026, he had to be arrested on the strength of the non-bailable warrant of arrest. As the said accused is a defaulter in his appearance and he had to be arrested only on the strength of the NBW, his conduct being not found to be good, the application stands rejected. Now, my submission before this honorable court, my lord, from the date of receive the summon, there was no intention of the present petitioner to evade the judicial process, my lord. I have annexed all the certified copy of the order. From the date of receive the summon, the petitioner continuously appearing before the additional chief judicial magistrate, my lord. My lord will find page 30 to 39, all the orders. My lord, on
Yes,
page
Mr.
30,
Bhattacharya.
Because otherwise, yes, conditions. My lord, initially he obtained bail, my lord, thereafter when he appeared before the CC.
No, Mr. Bhattacharya, you say this is not a bail application.
Yes, my lord, that is the difficulty.
my lord, here the extraordinary circumstances, my lord. From the order which I have shown your lordship, my lord, that rejection order regarding the conduct of the present accused person. But I have submitted all the certified copy, my lord, before the committed. From the date of issuance of the summon, my
Okay,
lord.
let the record come, we'll see.
Yes.
My lord, already, my lord, 100 days in custody, my lord.
Maybe you are defaulter.
Yes.
You are defaulter.
My lord, defaulter, my lord. The
And
case
we are
was-
examining that aspect.
My lord, the case was committed, my lord, and I was directed to appear before the learned session just on 31st/3/2026, my lord.
We'll say. Heard Mr. Hello, learned counsel for the petitioner, Mr. Bhattacharya, learned additional counsel for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 31st of March 2026, passed in session case number 108 of 2026 by the learned session judge Sunitpur. Where Sunitpur, full stop. It is to be noted here that by the impugned order dated so and so, the learned session judge Sunitpur has issued non-bailable warrant of arrest against the petitioner in a proceeding drawn under section 103 within bracket 1/3 within bracket 5 of BNS. Let notice be issued to the respondent. Returnable on Kobe.
On 7th September.
No, sort that. Second week of August.
My lord, on 14, my lord, I have some difficulty, my lord. May I pray on before 10, before 10?
Before 10. 7th of August, returnable. However, no formal notice is required to be issued since Mr. Bhattacharya entered appearance and received notice. But extra requisite copy of the petition be furnished to him during the course of the day. Registry shall call for the record of session case number
108/2020.
108 of 2026 arising out of the casually PS case number 1 of 2025. 2025. Fixing the matter on 7th of August.
My lord, kindly consider one aspect, my lord. The petitioner is absent only in one date, my lord. Only one day, my lord.
Maybe.
My lord, the case was submitted, my lord, I was directed to appear. Only
Hmm.
before the session,
But you failed to appear on the date fixed?
my lord, I have made some statement in my petition, my lord.
We will examine that matter after receiving the record
My lord.
from the trial court.
My lord.
Okay. Heard, Mr.
F. Judge Mojumdar.
Learned counsel for the petitioner. In this petition under section 528 of the BNSS 2023, the petitioner has prayed for causing the proceeding of PRC number 1111 of 2024 pending in the court of Learned Judicial Magistrate First Class Dhubri, and also the impugned order. No, also the order of taking cognizance dated 11/9/2024. And the FIR dated 17/4/2025, upon which Gauripur PS case number 98 of 2024 under section 153A and 295A IPC has been registered. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by Mr. Bortakur, you can represent the respondent number 2.
Yes, madam.
However, no formal notice is required to be issued since Mr. Bortakur entered appearance and received notice for both the respondents. However, extra requisite copy of the petition may be furnished to him during the course of the day. Registration call for the scanned copy of the record from the Court of Learned Judicial Magistrate, First Class Dhubri, pertaining to PRC number 1111 of 2026, arising out of Gauripur PS case number 98 of 2024. So you have referred one decision of Supreme Court. In which section it is applicable? 153?
295 and 153 also. Lordship, is 196 of the CIPC.
Hmm.
It mandates that in both the section, in case of 153 and 295, the prior sanction of the government is required. Lordship will find in the order of cognizance, it is a very simple and plain order. Nothing is there reflected that the sanction has been obtained.
No, whether you have raised the issue before the learned trial court at the time of taking cognizance.
At the time of taking cognizance, Lordship, I was not summoned. And I received summon after receiving the when the court took the cognizance, thereafter they issued summon to me.
Hmm.
So it was an extra
Whether charge has been framed against you.
The charge, Lordship, charge sheet filed and charge framed.
Charge frame. Whether at the time of consideration of charge you have raised this
Sorry,
issue?
Lordship, I'm sorry, extremely sorry. That charge yet to be framed.
Yet to be framed. Then why don't you raise the issue before the learned trial court at the time of consideration of charge?
Lordship, the law is very candid and clear that the prior sanction is required.
No, whether the trial court is not supposed to consider that point.
Yes. Lordship, this cognizance order itself, my submission before your Lordship is that
that should I wait up to the date to frame charge, because the cognizance order itself is illegal in violation of the section 196,
Mm.
and which is clearly mandates that sanction is required. And order of the cognizance, Lordship, clearly it is very plain and simple. May I read the section 196, Lordship?
Not necessary. So which section mandate taking up a sanction from the government?
Section 196, Lordship. 196 of CRPC.
Yes. And where is this decision you have relied upon?
That particular decision, Lordship, this section is very nicely explained by the Calcutta High Court with reference to the decision of Supreme Court.
No, in the synopsis of the petition, you have referred to a decision.
Yes,
Where is that decision?
Unfortunately, the decision I am not carrying with me, but another decision.
Okay, you produce the same on next date.
Lordship, I may produce this one. It is very nicely explained by the Honorable Calcutta High Court with reference to the decision of Supreme Court, Lordship.
Okay, you produce the decision of the Supreme Court.
Even then, Lordship, the decision, apart from the decision, the act is, mandate of the law is very clear, Lordship, the 196. And the decision just explained the mandate of the law. It is an inbuilt provision, statutory provision, 196, Lordship.
Okay, we will examine the matter.
Lordship,
Let's
Lordship,
call for the record from the learned
one more submission.
trial court.
Yes, Lordship, the matter may be examined in light of the established law, but the law says that yes, prior sanction is required. It is a statutory provision, and the order of cognizance reflects that there is no sanction granted or recorded by the competent authority. Lordship, another thing is that the word andabak, nowadays it has become a political slang targeting to the followers of a particular political ideology.
Okay, all right.
Lordship, my interim period may be considered in light of the section 96, Lordship.
On next date, let the record come.
Lordship, the
Okay.
statutory provision is very clear.
Okay.
There is a clear violation, Lordship.
Date. Date.
Lordship, my last submission, I am not submitting anything beyond the law.
Am I asking you that you are submitting beyond the law?
No, that is why
Then-
I am praying Lordship interim.
Next date we will consider after receiving the record. Interim period of the petitioner will be considered on receipt of the record from the learned trial court.
Lordship, on third, if can it be in the last part of the August any date? Lordship.
Okay, we will resume after 5.
May please, your lordship, the criminal petition for the quashing of the criminal proceeding, lordship. The lordship, the both parties are the heavily settled, the 498 A lordship. The petition number 1 is the informant and 2 is the accused. There is the brother-in-law of the petition number 1. FIR case lordship, burning
Amicable settlement.
lordship.
Where is the petition of amicable settlement?
The out of the court lordship, there
Whether any agreement is entered into by the parties?
earlier lordship, the one affidavit is where this the wife of the but that is
This
Submitted
respondent
before the
number 2
IO.
is the respondent number 2 is the informant.
who is the law accused lordship,
Informant.
brother-in-law of the informant, petition number 1,
Okay. Let him appear.
the lordship.
We will issue notice. Heard, Mr. N. Ahmed, learned counsel for the petitioner in this petition under section 528 of the BNSS 2023. The petitioner has tried for quashing the proceeding of PRC case number 4401 of 2025 arising out of Barbeta PS case number 2298 of 2021. Corresponding GR case number 5404 of 2021 pending before the Court of Learned Judicial Magistrate First Class under section 498A of the IPC. Read with section 4 of the Dowry Prohibition Act. On the ground that the dispute between the parties have been settled amicably outside the court. And the parties have resumed their conjugal life. Peruse the petition and the documents placed on record. Let notice be issued to the respondents, returnable in 4 weeks.
Joint petition lord.
However, no formal notice is required to be issued since Mr. Borthakur entered appearance and received notice. With the extra requisite copy of the petition be furnished to him during the course of the day. You are entering for both the parties.
Both the parties lordship. Joint petition lordship. Informant and the accused.
Borthakur? Borthakur?
Yes, ma'am.
498 Your Lordship, up to 3 years punishment, and section 4 of the door provision, 2 years.
But you see, the victim is not a party here.
No, Lord.
But the victim is need to be made a party. Means.
Who will compromise the case? The victim?
Both Lordship, the informant and the victim, Lordship.
So you have not implemented the victim as a party here?
Yes, ma'am.
It appears that the case was registered under section 498 AIPC, but the victim has not been arraigned as a party in this proceeding. Accordingly, it is provided that the victim, what is the name of the victim?
Somiran Parvin. Somiran Parvin.
Somiran
Parvin.
Parvin.
Lordship, I would do the petition file fresh with liberty, Lordship.
Later on, Mr.
Yes.
Ahmed, learned counsel for the petitioner submits that he may be permitted to withdraw this petition with a liberty to file a fresh one, impleading the victim as a respondent.
Party with him.
They are allowed. There's a petition stands dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Met your lordship. But this case, I take your lordships to page 41 first, my lord. There is an SOP from the government side to withdraw the petty cases. Your lordship is aware, my lord. Up to 3 years of my lord, punishment, my lord. So in my case, my lord, it was not an additional PP, file an application before the magistrate allow it. Again, that order of the other side has gone to revision, my lord. Session judge set aside the order saying that no, it will continue. This is the case, man. Now kindly see your lordship first page 41. Notification. Your lordship will find page 42. The government of Assam by notification, your lordship. Policy for dispose of the pending cases after due deliberation, the said committee in its meeting so and so has resolved to go for withdrawals of minor petty cases. The criteria for identification cases providing punishment up to 3 years. And your lordship will find then the case can be withdrawn except the following. These are the exceptions, my lord, 1 to Roman 10. So my case does not fall within that, my lord. Then your lordship will find why they have done it, page 43. Now page 40, application filed by the PP before the court, my lord.
Page
In
number.
terms of the notification,
Page number.
page 440. In terms of the said notification, my lord, this petition was filed.
Where is the order passed by the
Yes.
magistrate?
Magistrate order is page 48.
From page 49. Yes.
No, page 48. Only. Magistrate order. Page to see revision order. 48 is the order allowing the application filed by the PP. Then revisional order is page 49. Page 51 is important, my lord. The observation of learned session judge. Five bench, five judges.
So what wrong with this order?
Your lordship will find what's it, in terms of the, my lord, the SOP, this order was passed by the London magistrate.
Mm.
Then what the, my lord, learned session is saying, page 51,
Mm.
the public, it may be mentioned here that, page 51, my lord, first 3 lines
Mm.
there, that public prosecutor is not merely a mouthpiece of the state. Even if there is a direction from the state to withdraw from the prosecution in a case, he is still required to satisfy himself that public interest will be served thereby. Needless to say, the grounds for such satisfaction should be visible on the petition. Similarly, the court is also required to see that the proposed withdrawal will not thwart the course of law or cause manifest injustice. So this is how it comes, madam. Government has taken a policy in a meeting of the Chief Justice, Honorable Chief Justice and the Chief Minister. In the meeting, they have decided to streamline the matter, madam. Thereafter, a committee was constituted with the principal secretary. This committee has decided to withdraw the some of the cases, except some cases which are named in the FIR, madam, in the SOP. So ultimately, what is the use of 321, madam? 321. Section 321 says, my lord, they can do it, it can be done. So whether, my lord, when government has, what is the intention, what is the background of this SOP, my lord? You have to come from section 321. That power is given in the CRPC. And that power is exercised to the committee or to SOP or whatever it may be, my lord.
Mm.
Now the whole intention is of the government or the judiciary is, my lord, to minimize the pendency of the cases. The whole intention is that, my lord. So if this type of remark is made, my lord, every case will continue, my lord. Because PP has submitted an application in terms of the SOP. It is not saying that, my lord, PP's application
No,
is.
no, the session judge has relied upon 2 decisions of Supreme Court.
That decision, my lord, I have seen,
Mm.
those decisions are not, actually your lordship will find the 5 judges benches in 1987, there is judgment, my lord.
Mm.
These are 2 judges, your lord kindly see, man. Paragraph point of 69, 68, 69, your lord can see. 68, 69. Page 348.
Mm. Yes.
5 judges bench panel.
Mm.
68, my lord, the
Mm.
real question that has to be answered in this case is whether the executive function of the public prosecutor in applying for and supervisory functions of the court in granting consent to the withdrawal have been properly performed or not. The four remaining points enumerated above virtually resolved around this question. Number one, that's page 69. Section 321 needs three requisites to make an order under it valid. Number one, the application should be filed by a public prosecutor or assistant public prosecutor who is competent to make an application for withdrawal. This is satisfied in our case, madam. He must be in charge of the case. That is also done. The application should get the consent of the court before which the case is pending. So all the three criteria are here fulfilled, madam. Then I find that all the three requisites are satisfied here. The question is whether the function of the public prosecutor and the court were properly performed. At no stage was a case put forward by anyone that the application made by the public prosecutor was either mala fide or that it was not in good faith. There is no allegation of basis bias against the special judge. The application filed by the public prosecutor discloses the fact that he had gone through the case diary and relevant materials connected with so and so, so and so, so and so, so and so. So on the face of this, my lord, whether the court session judge order is sustained or not, my lord. There are 70, huh? Or 73. Yes, 73 also same thing. There are 73.
No, Mr. Chaudhary, you have not read the later part of this paragraph.
Which one?
This 60,
Page 70,
70.
last part.
70.
Oh, there is no allegation bias against that my lord. That I have read, my lord. The application filed by the public prosecutor discloses the fact that he had gone through the case diary and the relevant materials connected with the case, and that he came to the conclusion that in the circumstances prevailing at the time of institution of the case and investigation thereof, the case was instituted on the ground of political vendetta and only to defame the fair of image of a so and so. It is a particular matter with reference to Jagannath Mishra case.
Yes.
This statement of the public prosecutor has not been challenged as borne out by any so and so, so and so. It has not been made out or suggested that the public prosecutor was motivated by improper consideration. The only contention raised is that the reasons are not sufficient or adequate. So this also does not come in my case.
Going by the application filed by the public prosecutor,
Yes.
can it be said that the
Yes, page
requirement
41,
of
page 40, madam.
yes.
Page 40. As directed by your lordship, your lordship has seen the application, madam. Yes. As directed by the government of Assam by referred revision data so and so, by repeating for withdrawal of the cases. There is a case so and
That's
so.
paragraph number 3.
3. That I have independently assessed the materials available in the case diary and is the considered opinion that the withdrawal of the case is in the interest of the society at large. In view of the above, I pray your honor for to withdraw the case and all the charges so and so. So he has gone through that, my lord, and 321 also says this thing.
But you see, the decision relied upon by the learned session judge is not available with you right now.
Right now it is not.
So let us fix a date.
We have got this because larger benches, that's why you will not work that one.
No, that's all right.
I can supply, madam. We can go through that, madam.
This is a constitutional bench decision.
Yes.
Let us see the other two judgments relied upon by the
By the court below.
Yeah.
So I can
We'll
bring
fix a
it.
short date.
Yes.
Heard. Mr. SRS Chaudhary, Learned Senior Counsel, assisted by Mr.
Citation here, 1986.
Learned Counsel for the
R.I.
petitioner,
Chaudhary.
then Mr. Barthakur, Learned Additional PP for the state respondent. This petition under article, no, under section 528 of the BNSS 2023, read with Article 227 of the Constitution of India. The petitioner has challenged the judgment in order dated 23rd 3 2026 passed by the learned session Judge Hailakandi in criminal revision number 07 of 2024. It is to be noted here that by the impugned judgment and order dated so-and-so, the learned session Judge Hailakandi has allowed the criminal revision petition number 7 of 2024 and thereby set aside the order passed by the learned magistrate, Judicial Magistrate First Class Hailakandi, dated 2/5/2023. During the course of hearing, Mr. Chaudhary, learned senior counsel for the petitioner, has referred to a decision of Honorable Supreme Court in the case of Shivnandan Paswan versus State of Bihar and others, and submits that this is the constitutional bench decision. And in view of the observation made by the constitutional bench in paragraph number 69 and 70 of the petition
Several three also, man.
of the decision, 70
Several
Three.
three.
and 73.
Mm.
The impugned judgment and order so passed by the learned trial court is clearly not sustainable, and therefore he is contended to allow the petition. However, it appears from a perusal of the impugned judgment and order passed by the learned session judge that the learned session judge has also relied upon two decisions of Honorable Supreme Court in the case of Abdul Karim versus State, reported in 2000, 8 SCC, page number 710, Rahul versus Rakesh, reported in 2005 2 SCC, page number 377, and SK Shukla versus State, reported in 2006 1 SCC 314, and also another decision
2001, 2 SCC.
in the case of Sudhir and others versus State of MP and others, reported in 2001 2 SCC 688. However, the said decision relied upon by the learned session judge is not made available before this court today, and in that view of the matter, it is provided that recessal lays the matter on next Tuesday.
Obliged to. May I proceed? It's an application under 483. And if I have lodged to find page 16. Petition on the arrest on 21st/8/25. And day after this charges has been filed. Also kindly note on that this FIR was filed on 20 August 2025. And the alleged offense was on 23rd. After 1 month, after delay of the 1 month.
Is there
they-
any bar?
After delay 1 month almost,
Mm.
they giving a
No,
complaint to the
Mr. Borua, you say, in view of the decision of Supreme Court in the case of Gurmeet Singh,
Yeah.
delay is immaterial.
No, no. I'm submitting that after the 1 month, the complaint is that FIR has been filed. That is facts.
Hmm.
Thereafter, the charges has been filed and the trial has now started.
Mm.
Victim evidence has been taken.
Mm.
The last occasion, the Honorable Court asked me to submit the victim statement
Mm.
for consideration of the trial. On that view, that my submission was that whole case was a concluded case. That is not the fact that is the fact. But now the lordship will come on the affidavit I have brought on record, the victim statement. If lordship kindly have a look at the victim statement, then picture will be automatically clear.
Mm.
The page 29.
Mm.
They've been preferring this revision petition. So under 326 and 448, so delay may be condoned, Lordship.
Who is for the respondent? You are.
44. 326 or 448.
Heard means B. Sharma, learned counsel for the learned legal aid counsel for the applicant, and Mr. B. Sharma for the opposite party. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 59 days in preferring connected criminal revision petition against the judgment and order dated 10/2/2026 passed by the learned session Judge Gulagat in criminal appeal number 6 of 2021. It is to be noted here that
326, 448.
by the impugned judgment and order dated so and so, the learned session Judge Gulagat has dismissed the appeal preferred by the applicant and thereby upheld the judgment and order dated 6/1/2021 passed by the learned Chief Judicial Magistrate Gulagat in GR case number 1495 of 2017. It is also to be noted here that by the impugned judgment and order dated 6/1/2021, the learned Chief Judicial Magistrate Gulagat has convicted the applicant under section 326
326 and
326
448.
and sentence 326 and
448.
448 and sentence him to suffer rigorous imprisonment for 3 years and also to pay a fine of rupees 5,000 with default stipulation, and also to undergo imprisonment for 3 months under, and also to pay a fine of rupees 500 with default stipulation under section 448 IPC. What is the why it could not be filed in time?
The Lordship legal, they are 4 people, Lordship. Paragraph 3, Lordship, I have stated. They were not aware of legal aid and personally they could not engage an advocate. They approached us.
Ms. Sharma, learned legal aid counsel submits that the applicant is a poor person and also he is not aware of about the legal aid provided to the poor litigant by the District Legal Service Authority, and while she has been approached by which legal service authority approached you?
I have received it on 18/6/26.
From High Court Legal Service Committee.
18/6/26.
She has received a request from the High Court Legal Service Committee on 18/6/2026. And thereafter, she has collected the relevant documents, and in the meantime, delay of 59 days occurred, and the same is not intentional. rather circumstantial, and under such circumstances, she has contended to condone the delay and to admit the revision petition. Mr. B. Sharma, learned additional PP for the opposite party, submits that he has no objection in condoning the delay of 59 days in preparing the connected criminal revision petition against the impugned judgment and order dated 10/2/2026. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone through the application and the explanations so put forwarded by the applicant, especially in paragraph number 3. And this court is of the considered opinion that the delay of 59 days is sufficiently explained, and accordingly the delay stands condoned. In view of in terms of above, this IA stands closed. In view of the order passed in the IA, criminal number 717 of 2026, the registry shall register the criminal revision petition and list the same before the court as soon as practicable.
Lordship, can it be taken up on Monday? Because 3 years conviction, already 5 months he had during trial.
Maybe registry has to register it.
They will register if date is fixed on 3rd. In between they will because it's already there.
No, immediately they will place the same before the court after registration, immediately. If tomorrow they can register, they can list it a day after tomorrow also.
Apply.
Item 20.
May I please? Proceed? FIR is page 21, Your Lordship. And in vernacular version, it is 24.
You are behind the bar for how many days?
That
How many days you are behind the bar?
273 days.
273 days. Whether investigation is completed?
Investigation is completed. Already 3 witnesses were examined. And vital witnesses are examined, Your Lordship. And other 7 remain. Total witness is
Under
10.
which provision charge was framed?
Yes. Section 10 of POSCO.
What is the punishment prescribed for the
I don't fix that to you. Number 57. Item number 57 as per my instruction, Your Lordship. He was arrested on 28/4/26. So, officers have submitted a report and today is going to expire 90 days. So today, my lord, they will file application before the trial court for extension of the period. But otherwise, my lord, from the calculation, my lord, it seems that till date, there is no such application filed for extension of the, my lord, Your Lordship may kindly pay the report. From our calculation, today is 92 days.
90?
92 days. If my lord, 28/4, my lord,
Hmm.
28/4 and April, my lord.
And according to you, how many days you are behind the bar?
My lord,
According to you, for how many days you are behind the bar?
actually, my lord, if calculated from the date of arrest, then today is 93 days.
93,
And if calculated from the date of forwarding, then 92 days.
92 days.
Yes.
And according to Borthakur, it is 92 days.
92 days. my lord.
But till that, they have not filed any application.
But it is the, my lord, report of the.
We'll pass the order.
My lord. Apply.
Item 21.
May I please? 10 তারিখ 7 তারিখ given whatever. May I please, Your Lordship, the seed was called for Lordship, the seed was called for Lordship, earlier Lordship.
Not received, but my lord, notice start my report, I have received.
Notice served. Heard Mr. N. Ahmed, learned counsel for the accused. Mr. P. Barthakur, learned additional PP for the state respondent number 1. Mr. Barthakur submits that notice upon informant respondent number 2 is served, but no one entered appearance on behalf of the respondent number 2. Accordingly, it is provided that accordingly, who can be appointed?
That's no further.
A Gayon is a regular.
But she is mostly busy in the
Other matters. Puja Agora. Dr. P. Agora is appointed as legal aid counsel to represent the respondent number 2. Respondent number 2. Mr. Bortakur submits that he has not received the case diary. Accordingly, it is provided that Mr. Bortakur shall produce the case diary before this court on
Lordship on 7, Lordship. Today 64 days. 7, Lordship.
7th of August.
Lordship.
Okay, 7th of August. Recess shall reflect the name of Dr. Puja Agarwal in the cause list and also furnish the copy of the petition and relevant documents well in advance.
Wait, please, Your Lordship. The regular bail, Lordship, case diary was called for, Lordship.
in this case,
Then TCR can only be called for, Lordship. Because they are violation of section.
Started, submitted under section.
Given section.
PS number, my lord.
Given section.
Not. This is registered under section only 21C.
21 or 22 say?
22C, Lordship.
22C. Heard Mr. B. Chaudhary, learned counsel for the accused, and Mr. P. Barthakur, learned additional PP for the state respondent. Mr. Barthakur submits that after completion of investigation, the IO has submitted charge sheet in this matter. Accordingly, it is provided that recess shall call for the record, including the case diary from the learned special from the Court of Learned Special Judge NDPS Act, Barpeta.
Yes.
Barpeta. Record of Barpeta PS case number 44 of 2026 under section 22C of the NDPS Act, arising out of FIR lost by one because being on 8/5/2026.
CS number 57 of 26.
CS number 56 of 2026.
Obliged.
When race they will call for race when 10th of August. 10th of August.
Hello.
25.
Lordship, the call for the skin copy, Lordship. The skin copy, Lordship, call for.
Can copy. This is under section
21B, Lordship.
21B.
P, Lordship.
You are behind the bar for how many days?
44 days, Lordship. 44 days.
44 days.
Lordship,
Or
the-
Mr. N. Ahmed, learned counsel for the accused. Mr. B. Sharma, learned additional paper for the state respondent. Mr. Sharma submits that After completion of investigation, the IO has submitted charge sheet. Being charge sheet number
Charge sheet number 57 of 26.
57 of 2026, dated
1
21/7/2026. In that view of the matter, it is provided that registrar shall urgently call for the record from the Court of Learned,
Special Judge Amingao, Kamrup,
Special Judge Kamrup Amingao, fixing the matter on
7,
7.
12 is out of state.
Okay.
That level.
Item 26.
May be please follow. This matter, the accused petitioner behind about 422 days. And in this case, the co-accused has already been released on bail by this Honorable High Court, my lordship. Allegation under section 22B, commercial quantity of ganja was recovered and inside the train. But here in the seizure list, the name of the two accused person has not been shown, my lordship. And in this case, that out of the 6 witnesses, 3 witnesses has already been examined. And one with the seizure witness has stated that he has nothing know about the incident, lordship. And here the
So there are 6 witnesses.
6 witness
Out of 3 have been examined,
examined.
and one has not
One,
indicated the
yes,
accused.
seizure witness has stated that he has nothing know about the incident. I have annexed this next and already co-accused has already been released on bail in 298 days, my lordship. I have annexed this order also.
No, you have to satisfy the requirement of section 37.
Yes. Yeah. But
Merely because co-accused have been granted bail, we are not in a
Yeah.
position to grant you bail.
Yeah.
Unless you satisfy the requirement.
My humble submission so far seizure list is concerned. Seizure list concerned, the name of the accused person is not there. And here the 2 person was arrested. The how to count what quantity of the contraband has been
Let the scan copy of the record come.
yes, it is available in
Copy?
record.
Oh, okay. Have you gone through the same? So is there any material against him?
Materials are there from their position, it was recovered, madam. Seized by the policeman.
Then how the other person has been enlarged on bail?
Madam, he was granted, madam, the order is there, madam. The court bench has granted bail, madam. Here. Only on the 296 days he was in behind the bar. Page 52, madam. There are 5, madam. Force observation, madam.
Seizure list also does not indicate any such recovery. And in the seizure list, the name of the accused person is not mentioned. And it is stated that the recover from some SI. And here the 2 person has been arrested. And to establish the conscious position, my lordship, to establish the conscious position.
The articles were seized from one SI.
Yes, sir, yeah.
SI, whether that SI was examined.
Not,
Not
madam. Examined, madam. He was examined, madam. PW 3 examined, madam. Total 3 witnesses. PW 1 and 2 integrated the present petition evidence. From their statement, it is from his position, it has recovered.
But in the seizure list, it is seizure witness has stated that he has nothing know about the incident.
One
my
witness
lordship.
said that he
And my humble submission so far, the co-accused has already enlarged on bail, and he accused person has already been behind the
Maybe,
for 422 days. my
Mr.
lords, my
Kakuti,
lordship.
you see here, section 37 has not
Yeah.
been considered.
Yeah. But out of 6 witness, 3 witness has already been examined.
Implicated, madam. Only one not implicated, madam.
And taking all this aspect, my humble submission that he is already been behind over 422 days. And the enlarged accused person was behind over 290
Maybe.
90 days, my lordship. taking all this aspect,
We'll go through the case there, case record, we'll see. The evidence of PW 1 and 2.
1 and 2, my lord, 11 and records of 37.
We'll pass the order.
May I please, Your Lord?
Hmm.
20 days in custody, my lord. Games.
How many days?
20, my lord. 20 days, my lord.
20.
CD was called for in this case, my lord.
So what is the stage of investigation?
FIR, my lord, will be completed. 20 days in custody, my lord, considering the length of detention, my lord. FIR, my lord, will page 17, my lord.
Heard Mr. Tapatar, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PQ for the state respondent. This application under section 483 of the BNSS 2023 is prepared by the accused. Preferred by 4 accused person, namely Abdul Sabur, Nazar Ali, Ainul Rahman Haq, Soyod Hussein Khan, who are languishing in jail in connection with Hatigao PS case number 130 of 2026 under section 14 of the Assam Game and Betting Act 1970 since 8/7/2026. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one.
Kaushik Deuri, Sub Inspector of Police,
Mukesh
Hatigao
Sharma.
Police.
SI of Police, Hatigao Police Station. Is it Mukesh Sharma?
My lord, here it is Kaushik Deuri, my lord. FIR
At page number?
17, 17. Investigation part will be completed by
Okay,
Mr.
Kaushik Deuri. Okay. SI of Police, Hatigao Police Station on 7/7/2026.
Madam Mukul Chandra Sharma, madam. SI Mukul Chandra Sharma will investigate the case, madam. Page 17, madam. Last
No,
part.
17 is Kaushik Deuri.
No, madam, later part, madam, in pen writing, madam, handwriting, madam.
The court questions was who has lost the FIR. I have replied that Kaushik Deuri is the one who lost the FIR, and the matter will be investigated by Mr. Mukul Chandra Sharma, who is the Sub Inspector of Police.
The essence of allegation against the accused person are that they were found in possession of 15 numbers of T-ticket book, one softboard containing written T numbers, 3 Android mobile phone, case amounting rupees 5,200, one duster, and 3 numbers of sock. And they were engaged in illegal tea gambling and committed offense of the Assam Game and Betting Act 1970. Mr. Tapatar, learned counsel for the accused person, submits that the accused are behind the bar for last 20 days. And in the meantime, the investigation might have been completed and their further custodial detention may not be warranted in the interest of investigation, and therefore he has contended to allow the bail application on the ground of detention, considering the period of detention. Par contra, Mr. B. Sharma, learned additional PP. What is your submission, Mr. Sharma?
But my submission is I was collected some evidence against them, madam, and they were represented by the mother police, madam.
What is the stage of investigation?
But investigation is going on, madam.
No, what remains to be investigated now?
My lord, some of the cases examined, madam.
Per contra, Mr. B. Sharma, learned additional PP. Referring to the materials collected in the case, there is submits that the IO during investigation has collected sufficient materials and he has examined some witnesses. And some of the witnesses are yet to be examined. And therefore, he has contended to dismiss the petition. But having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents plus on record and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. It appears that the FIR was lodged on 7/7/2026, and since then, the accused persons are languishing in jail for last 20 days. The case diary indicates that the IO has already seized the materials from the possession of the accused persons, then also examined some witnesses. And in view of the
Accused persons also yet to be listed. Accused persons also some in the DR by the two arrested.
in view of the progress achieved in the investigation and also the period of detention, this court is of the view that further custodial detention may not be required in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 10,000 each with one security of like amount to the satisfaction of the learned Chief Judicial Magistrate, Kamrup and Gauhati, the accused person be enlarged on bail. CDB returned.
I'm deeply obliged, my lord.
Lordship, item 41 also out of same FIR, my lord, maybe taken out together.
29 is B and 41 is AB.
In this matter, my lord, FIR at page number 8, my lord. In this matter, my lord, a 23 years old boy committed suicide, my lord. He was having affair with a girl, my lord, and I am the father of that girl, my lord. FIR at page number 8.
Father of that girl.
Girl, my lord. Already 59 days behind the bar, my lord.
Why you have been arrested?
No, I have been named in the FIR, my lord, and it has been alleged that I used to threaten the victim, my lord, to end the relationship with my daughter, my lord. And she is a minor, my lord. I have annexed the birth certificate also, my lord, at page number 21A, my lord. Only 1 day left, my lord, for mandatory period. Only 1 day left, my lord, for statutory period, my lord. And
You have
59 days,
59 days.
my lord.
What is the stage of investigation?
Okay, this statement has been recorded, but still. The progress. Allegation is that the deceased and the daughter of the petitioners have some love relation or some relationship, and sometimes they also demanded money from the deceased person. He also used to pay through mobile net banking and sometimes. But one day they also all the persons. Subsequently, she had a love affair with another person, and they have threatened him with dire consequences, and for that he committed suicide. That consequences.
My lord, some love triangle also involved in the case, my lord. Apart from that, she's daughter is minor, my lord. I cannot allow, my lord. My lord. Birth certificate.
Mother and father of the card before you lost it.
Statutory period is 60 days.
Lost.
Statutory period is 60 days.
My lord.
So since the CD is here, it is very unlikely that a search sheet will be submitted. Or Mr. Aisali,
Actually, my lord.
learned counsel for the accused, and Mr. Lawford, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused. For it or does who has been languishing in jail in connection with Hazu PS case number 199 of 2026 under section 308 within bracket 2, 351 within bracket 2, 108 struck 3 within bracket 5 of BNS 2023. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Pradeep Malakar on 21st of May 2026. The allegation against the petitioner is that against the accused is that he has abetted commission of suicide by the son of Mukunda Malakar by subjecting him to continuous harassment and also due to intimidation and blackmail and extortion. Mr. Ali, learned counsel for the accused, submits that the accused was arrested on
My lord, 35.
38/5/2026 and he has already completed 59 days in jail hazard and statutory period will over tomorrow, and he further submits that further custodial interrogation of the accused may not be further custodial detention of the accused may not be required in the interest of investigation, and therefore he has contended to allow the accused to go on bail. Per contra, Mr. Locker, learned additional PP, has opposed the petition, producing the case diary before this court. He submits that the IU has collected sufficient incriminating materials against the accused, and therefore he has contended to dismiss the petition. Paragraph. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Locker, learned additional PP. It appears that the accused is behind the bar for last 59 days. The statutory period of detention here in this case is 60 days, and the same will over by tomorrow. Further, it appears that the IU has examined several witnesses and the investigation progressed significantly. And in that view of the matter, further custodial detention of the accused, in the interest of investigation, seems to be unwarranted here in this case, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned SJM Hazu.
No, my lord, JMFC has.
Learned JMFC Hazu. The accused be enlarged on bail. CDB returned.
My lord, 41.
Kavita Das. Who is Kavita Das?
She is the mother, my lord, of that girl.
Okay. Same day she was arrested?
No, it is AB, my lord.
Okay, she's AB.
My lord,
Okay, lady, why?
She and her mother and she demanded money from him that much also. Sometimes he paid also. He also paid money.
at that point, at relevant point of time, my lord, no affair was lost, my lord.
But
There
why
was-
money was demanded, that is not clear from the
Yes.
evidence. Why he was paid money, what under what threat he was demanded.
She is a lady otherwise.
Lots of.
She is a lady. Allowed.
All right.
Why?
May I please, your lordship? Lordship, my lord, 58. Petitioner was arrested on 7/6/2026, my lord, and as on today, my lord, already 52 days, my lord, behind the bar. 60 days offense. Lordship will find the FIR at page 13, my lord.
In this case, I have received the police report. My lord. They also received.
Page 13 is the, my lord, the FIR. May I read, lordship?
Page number?
Page 13. Is a translated copy, and lordship will find the vernacular at page 15. Lordship, after going through the FIR, my lord will find that prima facie it is not a case of POCSO, my lord.
You were behind the bar for how many days?
52 days, lordship.
52 days.
2 days, as on today. Now, lordship, POCSO 10, my lord, punishment for aggravated sexual assault. And lordship, the sexual assault has been defined in.
Who is appearing for the respondent? Number
No,
two?
my lord, not yet appointed them.
Service is complete, my lord, otherwise.
Will engage one legal aid counsel. Formality has to be observed. Heard Mr. Peters, learned counsel for the accused. Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that though service is completed upon the informant, respondent number 2, yet the respondent number 2 remain unrepresented today. In view of above, one Mr. Who can be appointed? Bijita. Miss B. Sharma, Bijita Sharma is appointed as legal aid counsel to represent the respondent number 2. Respondent number 2. Place the matter on
Day after tomorrow, my lord, kindly. A 19-year-old boy, my lord. Already 52 days, my lord.
on Friday.
Friday.
Friday. Friday. Rest shall reflect the name of Bijita Sharma in the cause list and also shall furnish relevant papers, the petition and the relevant papers to her well in advance.
Obliged, lord.
In this case, already petitioner number has been selected on 18, lordship. And page 14 is the FIR, and nothing has been reflected against the petitioner number 1 under okay, actually, lordship. And I am on interim, lordship. I have recorded my statement. Page number 14 is the FIR, lordship. Only one allegation, that's accused number 2, proposed for marriage with accused number 1. This is the allegation that we the nothing has been reflected from the FIR that and
We have received a CD report. And in 183 statement also, I have not any, there is no any allegation regarding the accused number.
petition number 1, accused number 2, petition number. He is the father of the petition number 2, lordship. Already he is arrested on the
Hasem Ali and Amjad Hussain. Amjad Hussain. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Roham Ali. The essence of allegation against the applicants are that the applicant number 2, no, the accused number 2, no, upon Amjad Ali, the applicant number 2 has a relationship with the daughter of the informant of aged 17 years, and also had sexual intercourse with her and recorded video of the same. And
May I please allow CD did not come?
she did not receive. She did receive. Heard Miss
Jan Khondokar.
learned counsel for the applicant, and also heard Mr. Locker learned additional PP. Mr. Locker submits that service report and the case diary is still awaited. Accordingly, it is provided that registration list the matter on 12th of August. Mr. Locker shall produce the case diary and service report on that day.
Oh, bless me.
39. Sorry, 27.
May please your lordship.
CS.
She has submitted, but.
PS number?
Against whom? Against with the. My lord, so far, my lord, instruction is concerned, my lord, now, that his name has not been, my lord, placed in charge sheet, my lord. Only against the accused number 1, my lord, so far.
You have the copy of the search sheet.
No, not my lord, not received, but.
Well, let the record come then.
My lord,
Let the record come.
my lord, that will be more better, my lord. Yes. That is much more.
Okay, that can also be done.
Yes, my lord.
Heard Mr. Asame, learned counsel for the petitioner. And Mr. Locker, learned additional PP for the state respondent. Mr. Locker submits that after completion of investigation, police submitted search sheet in this matter. But Mr. Ahmed submits that as per his instruction, the present applicant has not been search sheeted. Mr. Locker, learned additional PP, submits that he may be granted some time to obtain instruction from the officer in search concerned police station as to whether search sheet is submitted against the present applicant or not. Pair allowed, list the matter on? No, Friday? Right.
Obliged, my lord. Much obliged.
May please your lord. Application, my lordship.
My lordship, my name is not in the FIR, my lordship. No overt act, no covert act, no specific act, no category, nothing in the mention my name. My lordship, my name came into the specific that when the Koikus Abdul Latif interrogated in their forwarding report, my name is mentioned, my lordship. That is page number 18, my name into came, my lordship. Lordship, last time also I pressed for the interim protection, lordship said that we'll call for the case. If it does not come, then we'll consider a submission.
So,
So,
Mr. Locker, his name is not there in the
Nothing,
FIR.
FIR, nothing, nothing. No, nothing. No reference also mentioned. Thrown in my lordship. Nowhere in the mention, my lordship. And evidence is basically documented, my lordship. I'll cooperate, my lordship. Evidence.
Heard, Mr.
Lordship, I'm praying for interim, my lordship, kindly. Aramin, my lordship.
Learned counsel for the applicant and Mr. Laskor, learned additional PP for the state respondent. This application under section 482 of the BNSS 2023 is prepared by the applicant. Namely, Abdul Aziz, who has been apprehending arrest in connection with Kolgasia PS case number 54 of 2026 under section 3184, 3162 of BNS 2023, it is section 14 of the Game and Betting Act 1973. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Who lost the FIR?
Lost by the SI, my lordship. Page number 18, my lordship, 90. SI Jitul Das, my lordship. Kolgasia.
Jitul Das of Kolgasia PS, Barpeta, on 31st of May 2026. The learned counsel for the applicant submits that the applicant is innocent and his name find no mention in the FIR. And since the learned additional PP has failed to produce the case diary today, he pressed for granting interim protection to the applicant. Per contra, Mr. Mr. Locker submits that he has not received the case diary and he pressed for listing the matter. No, pressed for granting him short time. Pair allowed register list the matter on and in the interim, in the event of arrest of the applicant, he shall be released on PRS bail on his executing a bond of rupees 25,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions.
Protection that not Loveless, my lord. I loveless.
Sorry, my lord. In item 37, my lord, there is interim, my lord. Interim will continue, my lord. In item 37. Obliged.
May I please your lordship? Lordship, in this case, what when this petitioner was convicted under section 130 of the NI by the trial court, subsequently his conviction was affirmed by appellate court, and then he preferred a revision petition which was dismissed. Now this criminal petition has been preferred for setting aside this conviction on the ground of the settlement between the parties here also. I also annexed this compromise petition also, deed of compromise brought. Page number 57. Page number 57. It start relevant part from 58.
Yes, is there any compromise between the parties?
Yes, compromise. And as per the compromise, they agreed to payment on my lord 59, para 59 last part, my lord. Part facing they will pay. Second party.
Hmm.
One lakh by lord, 12th of August. Next 1,50,000 my lord, 12th of November. And then next 1,90,000 remaining person. 127.
So on the basis of this deed of compromise, we can quash the proceeding.
Lordship.
Yes, we still as per discussion on no objection he raised.
No objection.
No objection he raised.
Their actual check amount was 4 lakhs, your lordship. Then well, at the time of conviction, it was made double of the amount. Check
No,
amount.
now the question is if the parties have settled
Yes,
the
both the parties.
dispute,
Yes,
then we will not enter into the merit of the case.
lordship. Lordship. At present, this petitioner is behind in Borpeta jail, your lordship. He is serving the sentence.
Is behind the bar.
Your lordship. On 23rd April, he was arrested, your lordship, after dismissal of this revision petition.
But can we entertain this petition at this stage?
Lordship.
Can we entertain this petition at this stage?
Yes, lordship. This is under 147, your lordship.
Hmm.
This compromise on behalf of his petitioner, his wife has entered in the compromise.
That's good.
In this, I have submitted one this judgment of this honorable court, your lordship, in which in similar situated case, this court has allowed this compromise, your lordship. Para 18. In this case also, this petition was behind the bar.
Maybe here the court has relied upon some of the decision.
Lordship.
Where are those decisions?
I have annexed 2 of the judgment in my petition also, your lordship. Is on page number 67. Was. The judgment of division bench judgment, your lordship.
Is there any decision of Supreme Court on this point?
Lordship. Here in one of the Supreme Court judgment, it was stated that therefore
is
it is
that?
very clear that although dishonor of check entitled criminal consequences, the legislature by virtue of section 147 of the NI Act has made it compoundable, notwithstanding the provision of the Code of the Criminal Procedure 3. And same can be compounded at any stage of the proceeding, especially when the parties have themselves arrived at the voluntary compromise. It is there, Lord.
One decision of Supreme Court is there, that is Damodar S. Prabhu.
Yes, Your Lordship, it was.
Is it available with him?
I have not printed out this.
Produce it on Thursday.
Your Lordship, if matter will be possible for time being, I will collect this judgment, Your Lordship.
Okay, bring it.
After some time, Your Lord, I will draw the judgment.
Heard, Mr. Learned counsel for the accused. And also heard Miss
M. Deka.
Learned counsel appearing on behalf of Mr. S.C. Kaya, Learned standing counsel, Custom Department. Learned counsel appearing for Mr. S.C. Kyle submits that Mr. Kyle is in legs in another court and say press for listing the matter on some other day. Pair allowed, list the matter on
7. 7. For hearing. Number 45.
My senior is coming.
Pardon?
My senior is on the way.
Who is your senior?
T.H. Hazarika. Item 40.
Visible নহয় কৰিব পৰা গৈছে যে
Mr. Hazarika against which judgment you are
My lord,
preparing
yes.
this
My lord,
appeal?
trial court, there were two sections cognizance was taken under 498A and 494.
No.
498A,
This
my lord,
revision petition is against criminal appeal number 22 of 18
Yes,
or
ma'am.
4 of 19.
yes, that is why, my lord. My lord, trial court, two sections, it was, judgment was decided on two sections 498A. 498A was acquitted by the trial court. 494 was conviction. So against 494, my lord, the accused person preferred appeal. And in the appeal, my lord, he was, order of conviction was set aside and he was acquitted. So, my lord, after that, my lord, we have,
So
against that,
this revision is against acquittal.
yes, my lord, what 942/2020 criminal appeal, my lord, that is against original order of conviction by the trial court, appellate court acquitted. Appellate court acquitted, my lord. So against that acquittal, we have come before this honorable court. Appeal against acquittal.
And another petition, my lord, connected petition, my lord, that is revision petition, because my lord 498 original trial court acquitted, then appellate court, when the matter was appealed by the state, it was came, that same order was upheld. So twice there were acquittal, my lord, by the trial court and the appellate court. So against the appellate court, we have filed revision.
Against who is appeal now?
My lord, here
There are two appeal. One is 22 of 2018 and
Yeah.
the other is 4 of 2019.
yes. Yes, my lord. Here,
Against who is appeal you are preferring this
yes,
revision?
my lord, I'm just. My lord, at page number 15 of the 92 of 2020 criminal revision petition, page number 15, it will be clear, my lord. Yes. 1942, my lord. Oh. Item 46, my lord. This revision and appeal are from the same common judgment of the trial court. That is why, my lord, page 15 of and item number 46, it will clear, my lord. Judgment of the criminal appeal. Learned lawyers for both sides are present. Judgment is prepared and delivered. The criminal appeal number 22/18 and criminal number 4/19 have been disposed by common judgment. Then-
Mr. Hazarika, you say whether this one is appeal, other is revision
Yes,
is maintainable.
my lord, because trial court, my lord, did convicted in one section, acquitted in another. So where the accused was acquitted, my lord, state went for appeal, and where he was convicted, my lord, he went for appeal for against conviction, and these two were decided together, my lord. And in that in the appeal and 494, which the trial court convicted, my lord, appellate court acquitted him.
No, my question is,
Yes.
can you maintain one appeal and one revision against the same impugned judgment and order?
Same impugned judgment, but my lord, there are two parts, my lord. So two
Maybe,
appeal were there. In the appellate court, my lord, two appeal lied. One was against acquittal and one was against conviction. Against conviction by the accused. So two appeals were there in the trial appellate court, my lord. One is 22 oblique, one is 18 of oblique 22/18, and another is, my lord, 4/19. My lord, here.
Yes, Mr. Portagar.
My lord, actually one appeal argument for the some court filed by the state.
State.
And that, my lord, appeal was dismissed by the session court. And against that appeal, my lord, she has been found one criminal
Revision.
one criminal revision. And another is, my lord, he is also, my lord, convicted, acquitted under section 494. Against that, my lord, one other appeal is there, my lord, appeal against acquittal. One is appeal against acquittal and one is revision petition.
My lord, I will just simplify, my lord. This informant was the wife. Against husband, my lord, under two section cognizance was taken under 498A and 494. In the 498A, learned trial court found that he is not guilty and acquitted. But in 494, he found him guilty. So, my lord, state appeal against the acquittal, where under 498A, where the accused was acquitted, and accused preferred revision against his conviction. So both appeal came together at page 15, my lord, by two different appeals, my lord. Not one appeal. Against the same judgment, two appeals were preferred. One by the state, one by the accused. Accused against conviction.
No, therefore, my
yes.
question is, can you maintain
Yes.
simultaneously one appeal and one
Yes,
revision
my lord.
against
My
that
lord, why that is, I have written, my lord? Because trial court originally.
No, that I understood.
Yes.
But whether it is legally permissible?
Permissible, my lord, because now, my lord,
Can you
yes.
show me the relevant provision?
My lord, here trial court where acquittal was there.
No, you show me the relevant provision.
No, no, regular appeal and revision, my lord. Against acquittal, we always come by way of a revision. Because appeal is decided on the question of acquittal. So there cannot be further appeal against acquittal. There cannot be two appeal, my lord. Already appeal against acquittal has been exhausted in the trial court.
No, that's all right, but here against the common judgment.
Appeal, my lord, common judgment, but against ordered against two separate appeals. Two separate appeals, my lord.
So see, the legal provision, is it permissible?
My
or
lord,
not?
this part has already been admitted, my lord.
Oh,
Here in this honorable court, admission of this, admitted. Huh? Yes, my lord, it's already admitted by this honorable court.
admitted already, but whether it is maintainable?
Maintainable, my lord. That part we have already, my lord, earlier, my lord, we have submitted on that part. So admitted, my lord, for hearing.
Where is the order?
Let's have a look, man. We have to see the record, man. Because now it is filed, fixed for hearing, my lord. So only after admission. Hearing got taken, no? Actually, my lord, in the trial court, my lord, the trial court has decided in two separate, my lord, issues, two separate issues.
So far the trial court is concerned, there is no problem. The problem is regarding the appellate court judgment.
My lord. Trial court, my lord, in the trial court, my lord, trial court has separately dealt with the.
You come with a relevant provision. You show me the relevant provision.
My lord, whenever in a trial, my lord, when some accused is convicted, my lord, he will go for acquittal. He will go against, he will go against the conviction. My lord, here appellate court acquitted him, reversed the conviction. So when by
Against that, this revision will lie, that's all right.
My lord.
But against the 498A
acquittal,
conviction,
my lord. Yes,
acquittal.
my lord, because
You have preferred
appeal has already.
second appeal before the.
Yes, we cannot file, my lord, because state has already exhausted, filed the appeal against acquittal. Therefore, my lord, only because there can be again a second appeal before his honorable court. There is no provision of second appeal in a criminal case, my lord. So we have to prefer by way of a revision.
No, here you are preferring appeal against which one?
Appeal against acquittal.
Acquittal of.
Acquittal by the appellate court as well as the trial court. Trial court acquitted under 498A, then state preferred appeal or appeal against acquittal. So appeal against acquittal has already been exhausted in the sessions court, my lord. So we cannot, this is my humble submission, my lord, we cannot file a second appeal. So only way to come is by way of a revision, my lord. So we have filed a revision.
And the appeal then?
Appeal in the other case, because originally conviction was by the trial court, the accused went for setting aside the conviction. His appellate court set aside the conviction and acquitted him. So for the first time, we are filing appeal against
not
acquittal.
second appeal before the court, before this court?
No, my lord, because appeal not by the same party. Appeal cannot be twice by the same party. They had a husband appeal against the conviction. Now since he has been acquitted by the appellate court, so we are agreed. The wife is agreed. Little bit confusion.
No,
My
Mr.
lord, may I
Bordakar, you
add-
say. Mr. Bordakar, you say. Trial court has convicted the appellant in 494. And session court has set aside it in appeal. And is this not second appeal before this court now?
No, my lord. My lord, conviction by the appeal, that under 494 conviction by the trial court. Husband went for appeal against conviction.
You are repeating the same thing.
No, my lord.
List the matter on next Monday. We'll see.
My lord, may I pray?
For further consideration.
My lord, here, my certified copies, my lord, I have seen, my lord, are not very legible. Can a copy be given of PW 1 and 2, my lord? I have the certified copies, my lord. Are
We have obtained certificate copy from the registry.
my lord, I'll just show, my lord. My lord, this is the type of certificate. We are not able to, my lord. Like 2 pages, are legible pages, my lord. Okay.
You apply here.
Here, my lord, can we get a copy, my lord, to buy?
Pardon?
Photocopies, my lord, of this.
You apply
Yes.
for the same before registry.
Yes.
Registry will furnish
Then,
from the
my
record.
lord, some time may be given for that because.
Tuesday. Okay, 11th of August. 11th of August. You apply for the certificate copy, registry will provide it.
Yes, yes.
Copy, is there any bar in providing? The record is available from record they can furnish. You can apply.
Yes.
I mean 16.
Which is the relevant paragraph here.
Lordship. Yes, Lord. From para 18, your lordship. Para 18. Page 670. Para 18.
So para number 21.
Lordship.
the guidelines.
Yes, here is guideline, Lordship.
Yes. Before the High Court, it is 15% of the SEC amount.
Yes, Lordship.
By way of cost.
The Lordship, in this case, already he is behind the bar. Already for last 3 months, he is behind.
No,
the bar.
no concession is provided here
Lordship.
for those accused who are languishing in jail hazard.
It is correct.
Is it?
Lordship. It is upon the court, Lordship.
My further exactly, the petitioner is a government servant.
Pardon?
Is a government
He is
servant.
a government employee, Lordship.
My contractor is job maybe.
Okay. No, that's all right, but these guidelines Supreme Court has laid down. These are to be followed now.
Yes, sir.
So as per this guideline, he has to pay the 50% of the SEC amount as cost. What was the SEC amount?
Check amount was 4 lakhs. And
4
the time
lakhs.
of this punishment, it was made double of the amount, 8 lakhs euros.
8 lakhs.
8 lakhs. Already double of the
15%
amount,
of the SEC amount would be what?
Lordship.
360. 360,000 he paid out of 8 lakhs.
Paid.
Yes.
Already 3 lakhs 60,000 paid euros.
Where it is mentioned? In the compromise petition.
7. There are 9.
Okay, we will pass the order.
Obliged.
May it please, Your Lordship. The present petition is regarding the enforcement of the DV proceeding presently pending before the judicial magistrate first class at Gauhati, Lordship. The basic fact of the case is that due to familial discord between the petitioner and the respondent number 2, the petitioner has preferred a divorce proceeding before the family court at Gauhati, and that was pending, and that was filed on 25/6/2025, Lordship. And as and when the divorce proceeding was filed, the respondent number 2 left the house of her in-laws, Lordship, and she preferred a DV proceeding before the judicial magistrate first class, Lordship, at Gauhati.
What are the grounds?
The Lordship may come to ground number 4, 6, and 7, Lordship. May I read it, Lordship?
Yes.
For that, Lordship, both the petitioner number 1 as well as the respondent number 2 in the instant petition are fully aware of the facet of cruelty, more so mental cruelty, which is allegedly suffered by the petitioner number 1. As such, the institution of impugn proceeding under CRDV number so and so is.
My learned friend has come to the honorable court, challenging the entire proceeding. It is my statute has given me the right. When he has ousted me from the house, I with 2 children living separately. How I survive, my lord? So I have filed 125. No interim order was passed. They have filed the divorce, and my lord, that's why I filed domestic. There is also no interim order. Still going on for evidence. Court has not yet granted any interim protection.
I am very much hardship. And well, if in this stage, but the whole proceedings, what relief I will get from it. That's why my probably my friend has come before the court very immediate stage. It should not be entertained, madam.
No, this petition has already been entertained.
Yes.
And the other ground, Mr. Bora,
Lordship, ground number 6 and 7, Lordship.
6 and 7.
The ground of mental cruelty they have already taken in the divorce petition.
That is there in the Lordship, their WhatsApp messages, page 39, Lordship.
Ground to court.
No, this paragraph number 6, sorry, 39 here relates to maintainability of the
Yes,
petition
Lordship.
under 482 for causing the domestic violence
Civil
proceeding.
nature, Lordship. To the act is civil nature, Lordship, it can be quashed at any stage of proceeding.
No,
Lordship.
there is no doubt. Mr. Biswas has also not disputed the same. But the grounds you have mentioned, you have taken
Yes, Lordship.
in the petition
Yes, Lordship.
is to be considered.
That is correct, Lordship. I've already given.
There is also saying that the second part, section 42, please save the inherent power of the High Court, prevent the abuse of the process of any court, or otherwise to secure the aims of justice. Therefore, in a given case where the learned magistrate is dealing with an application under section 12(1), High Court can exercise the power under second part of the 42 to prevent the abuse of the process of any court or to secure the ends of justice. Hence, High Court can exercise jurisdiction 42 to quash the proceeding of an application order passed in accordance with 18 to 23 of DBI. Now the question is to what scope in comparison 482 with the proceeding of DBI, we must make distinction between the proceeding initiated on the basis of the application under section 12(1) of the DBI, which are predominant of civil nature, and the proceedings under criminal code of for prosecuting a person for any offense, setting criminal law motion has very serious consequences affecting the liberty of the human being, as the person against whom criminal law is set into motion can be arrested and sentenced, yet there is no scope of that. We have already referred the objects of the regions of the DBA, which are produced in the decisions of this court in a case of such and such. The basic objective of DBA is to protect the woman from the being a victim.
Mr. Biswas,
and also to prevent the occurrence of the domestic violence in society.
Mr. Biswas,
Yes.
which judgment you are reading?
Well, I think my friend has given to you, Lordship.
Which one?
That is, Lordship, that is there in paragraph 34.
No. You please go through the other decision relied upon by him. K. Srinivas versus K. Sunita.
It's not with me, madam.
No.
I'll find out.
You take down the citation 2014 16 SCC page number 34.
Volume, madam?
16.
I'll find it.
We will keep the matter as parted today.
Yes, sir.
Heard Mr. Bora, learned counsel for the petitioner, Mr. Biswas for the respondent. Heard in part, lays the matter on sorted
$30. 2014.
as parted.
2014.
650. There it was. About 600.
Madam, 2014 SCC 34,
11.
volume 16. It took like
Obliged, Lordship.